All right, so there is this absolute explosion of elder abuse and exploitation in this state across this country. And I want to talk a lot about it because it's not well enough known that people understand how to respond to it. We are all seeing elder abuse and exploitation, but many of the people who are around, loved ones, friends, caregivers that are seeing elder abuse and exploitation, don't understand what it is exactly and how to deal with it. So the purpose of this video here is to make very clear what elder abuse and exploitation is, and I'm going to point specifically to statute and some definitions that are critically important. Most important thing to understand is there are two components of elder abuse and exploitation in law in the state of Florida. The first is the criminal side of things, 825-101, and then there's the civil side of things, Florida Statute 415-111. They largely mirror one another, but they can be mutual. They can be exclusive. They don't need to be, but you can have a civil cause of action that doesn't cross the line into criminal. You can have criminal that I guess maybe doesn't cross into the civil side of things. But again, because the definitions are basically the same, I want to focus on the definitions first. The most interesting thing, and I think what's really important to pay attention to, is what is a definition? A disabled adult is someone 18 years or older who suffers from a condition of physical or mental incapacitation due to a developmental disability, organic brain, or mental illness, or has one or more physical or mental limitations that limits the person's ability to perform the normal activities of daily living. Here's the deal. That can be anybody under that broad definition. So we've got people that have obviously long-term disability, particularly when they're elder and they're not coming back. But if you look at that definition, this could also be sort of transitory. When I look particularly at mental illness or mental limitations that restrict the person's ability to perform activities of daily living, that could mean the perfectly functioning mom who gets into severe alcoholism or drug addiction. We see this with like people coming out of bad surgeries, they get hooked on drugs, their life spirals, and you can't get them out in control again. This could be that a 20-year-old kid that goes off to college, maybe has a traumatic experience, they get PTSD, they're kind of going over the edge. That could provoke mental illness, and that could provoke one or more physical mental limitations that restrict their ability to perform. The kid comes back with, let's say, a severe eating disorder, and you can't get the kid out of the room. You've taken him to doctors, that's not working, but that mental limitation restricts the person's ability to perform activities of daily living. So now we get back to what is the lack of capacity to consent. So the person suffers one of those conditions. They're under a rough period, and they really start to lose their ability to consent. And again, under this broad definition, it could be just about anything. In supporting this broad definition that I argue for under disabled adult is, what does it mean lacks capacity to consent? And this clearly defines that chronic use of drugs, chronic intoxication, could be a condition that tells the judge, hey, kid's been drinking, mom's hooked on drugs, dad's hooked on drugs, and I need you, judge, to step in here and do something about this. What it really speaks to as well is that there's someone that's gotten their hooks into this victim, and that someone is obtaining or using their property, their resources, their assets, their home, their car, their whatever, and they are the perpetrators of this exploitation that is defined up here further. Now, again, back to the concept that this is largely mirrored in 415-111, where this comes into play is that, kids are living up in Michigan, and they realize that dad's down here and has a new girlfriend, maybe it's a new wife, and because dad suffers from these conditions that would define him as disabled, the wife, girlfriend, boyfriend, whatever, kid, some people have like a sibling that's down here taking advantage of dad. They are exploiting dad. So you don't just sit there helpless as a loved one watching someone be victimized and exploited. There's this civil cause of action. you get in court right away and you say, Judge, this person's being exploited, lay out the facts. It's great to be able to build up those facts, right? So that means like bank statements, that could be text messages from either the victim or the exploiter. We get that evidence together and you can put it into a form that the judge can understand and read clearly. Now, I want to talk about what is sort of the emergency situation and how you respond to it immediately. So you're up there in Michigan and you got a kid down here that you know is in a real bad time, and you can tell that she's running with the wrong crowd. She's being exploited. What do? Do you just sit up there in Michigan, confused, scared, worried about your kid that's down here that you know is in a bad space? No. There's this injunction. The injunction for protection of exploitation has been created relatively recently. Here's an interesting thing about statute that you need to know. When you scroll down to the bottom, this is called the legislative history, and you can read exactly everything behind it. So back to 2018, when this began, relatively new, and it gets amended just a couple of times along the way. That's critically important for me as a practitioner because, when I file something now in 2026, I go all the way back to the history, and if I can find that my case is lined up specifically to where one of these things changed, then I really want to emphasize to the judge that, Judge, this is a set of facts that line up directly with why they amended it in 2025, or Judge, in 2024, this was expanded by the legislature precisely to cover the set of facts that are before you on this injunction. Well, let's talk about what an injunction looks like. So you're up there in Michigan and your kid's down here and you recognize that they're being exploited. You look at the definition of statute that I provided to you and you get real comfortable with the facts. You check yourself to make sure you're not kind of overreacting, you're not misperceiving events. You make sure that you fit within the definitions of who can file, and we'll get to that in a second. But you file this thing. And I think what's so important about the petition for injunction for protection against exploitation is it sets about a non-discretionary chain of events where the judge has to review this. Experts have to get involved and look at this. And there's another part of injunctions. I get calls all the time about people that go, they're wringing their hands. Should I do this? Should I not do this? And here's what I tell people. If you suspect this at all, do it. Because the last thing in the world that you want is that you're concerned about this, but you don't take action. Now, you're not an expert, and you need to have these set of facts that you're concerned about reviewed by an expert. That's a judge, that's the caseworkers, that's the other experienced professionals that know what the facts are. But I say this to people all the time. If you suspect it at all, file so that it's out of your hands. You place it in the hands of the judge. Judge has seen this all day long, sometimes for decades, and they'll know whether or not relief is necessary or relief is required. So the next thing I want to talk about is, what specifically does this petition look like? And the critical thing to understand is that in just about every county in this state, there are courthouses that have on the bottom floor exploitation and injunction hearing rooms. And they've got volunteers in there and they've got paid staff that walk you through precisely what the injunction is. And, if you're thinking about this, if you're concerned about mom, dad, grandmom, kid, anybody down here that's being exploited, I'll have the links in for all these things, but you can Google it yourself and pay very careful attention to what these definitions are. And, if you're really going down this pathway, make little checks boxes along the way. I check. Let's talk about, is this really exploitation? Are there adults being deprived of their funds? Yeah. Their capacity diminished? Yeah. Is a breach of fiduciary duty? Has someone misused a bank account? Check. Who may file the petition? And then where to file. And it's just, plug and chug. Good information that's in there. I can tell you here's what happens. So you're sitting down on the bottom floor of the courthouse, you're filling this stuff out, and you're getting your facts in here straight. These lines are really important, right? So you want to be clear with what facts are. You want to make sure that you're writing facts in there that are, number one, 100% accurate. No embellishment. Damn sure better not be lying. Better be crystal clear about it. Understate if necessary. Don't overstate facts, because there's nothing that turns a judge off more than when you overstate facts improperly. But in any event, you want to think about this from the judge's perspective, right? So you're filling this petition out, and you got to ask yourself, if I'm the judge that's sitting there reading this thing, what's the judge going to see? What's the judge going to feel? What's the judge going to understand about the victim and the perpetrator? So that should be front of mind when you're writing this thing. Hopefully you collected some evidence. You got text messages, it's really good. Financial institutions, snapshots, emails, those kind of things. That stuff is critically important, which brings up an important point. And that is, if you think you're heading down this pathway, really important to engage both the perpetrator and the victim, right? So get some communication going. Get them to admit facts. You took dad's money. Why do I see in dad's bank account that there's $50,000 missing? These kind of text messages, this kind of evidence, it can be critically important in showing a judge exactly what's going on. But here's the deal. This injunction, the moment that it's filed downstairs in the courthouse, per chunk, it's upstairs to the judge. And the court's got a lot of respect for the way they treat these things these days. The people down there will help you go through this, fill it out. And then again, like I said, in minutes, it's upstairs to the judge who's going to read these things. I deal in probate court all the time. And quite frequently, judges will just stop in the middle of a proceeding because they got a hot one on their desk. And the judges take this stuff super seriously. You can see sometimes they'll just tell you, everyone go back to your seats and give me a minute here, because a bailiff's walked in and handed one of these things, and the judge is thoughtfully considering what's going on. And, maybe it's granted, maybe it's denied. But here's the deal. After the judge reviews this thing, this sets up a chain of events under statute where it's provided to the respondent. And the respondent is given the opportunity, the demand, given the invitation, given the compelled to come to court immediately and explain to the judge what's going on. Let's talk about what happens next. So judge reads this petition, determines that it's valid. Judge orders everybody into the courtroom immediately. And we're talking days, right? So you're in the courtroom, within a week. And the judge wants facts, and you raise your right hand. You swear to tell the truth, whole truth. Yeah. Sometimes people need to take the fifth and say, I'm not going to answer this. But in any event, judge has a couple of choices. The first thing that's really important about this is the judge has massive power. The statute here on this final hearing, the court may grant such relief as a court judge proper when there's been notice. But it's broad relief. I don't know about anything. That's another important point. There's no case law on this. But what the legislative intent here clearly is to put power in the part of a judge to freeze assets, direct that all assets be returned, or the respondent to participate in treatment, intervention, medical care, can immediately impose serious penalties about anybody who's victimized someone. So sheriff is given this information. It's given to the victim. It's given to the respondent, and a final judgment's entered. Another important thing, this abuse hotline, 1-800-962-2873. In my experience, these people are very serious. They're very experienced. And again, back to this point, when you have resources of experienced practitioners, doesn't cost you lawyer fees, doesn't cost you fees, period. You call this abuse hotline and share the facts with them. Sometimes these people will kind of settle you down, explain to you, yeah, it's not really there. That's not exploitation. You need to back off. I have real confidence in their ability to sniff out, exploitative petitions. When people are going to take advantage or get a leg up on a brother, a sister, a spouse, whatever. But if it's real, these people send out investigators right away. That's the way this state deal works right here. You report it. They got a real good triage system where experienced practitioners look at this, and then they will get out there and make an investigation immediately. So again, we get this circumstance where, someone's living down here in Florida, kids are up in Ohio or wherever, and they're concerned about mom or dad. And I say this all the time. There are two things you can do. Number one, you suspect financial abuse or physical abuse or other abuse, call the abuse hotline immediately. Another one that's really important to keep in mind, and that is wellness check. We have law enforcement departments all across the state, city cops, sheriffs, and if you are at all concerned about anyone, kid, 18 years old, 20, whatever, elder, 80, 90-year-old grandma, granddad, dad, mom, dad, alcohol, drugs, whatever, call for a wellness check. Cops have a real good job of showing up there, knock, knock, knock at the door. You know, what's going on, Matt? Your kid's called from Ohio. We're doing this wellness check, or it can be confidential, but we're here just to check on you. What's going on? If everything's okay, they report back to you. Everything's fine. Dad's just on a bender, but we think he's coming out of it. But if something's wrong, they can get those services immediately. So wellness checks. So that's the whole side of the criminal side of it, 825 and the injunctions that can trigger a whole criminal investigation. But I am focused on 415-111, and that is the civil side of things. So we've determined that mom, dad's being exploited. We've determined that the caregiver that was taking care of grandmom, granddad is down there helping themselves to the bank account. And same deal. Judges have immediate power to get in there and freeze everything. So stock accounts, bank accounts, vehicle transfers, titles. There's one interesting thing in there that it doesn't affect the title to property. Somewhere in here, don't know where it is right now, but it's just very interesting to me. But the bottom line is this: this has the ability under 415-111 to provide civil actions. Another thing that's critically important is speedy trial. So these folks that are 65 years of age get to the head of the line, and they should. The presiding judge may advance the trial on the docket, file it immediately. It's what I do, or wait till things progress. But I want this to the head of the line immediately. I want that adult person's funds back in their account immediately, and I want the judge to give this the attention deserved. One final thing that I just think is bizarre, but here we are in Florida, and while lots of stuff is good, this section here, statutory construction, treatment by spiritual means. I don't know what in the world, I didn't read the legislative history on here, but sometimes back in 1985, as you see right there, somebody felt necessary to say that if someone was with a shaman, I guess a cult or whatever else like that, they couldn't be compelled to get out of that cult or go to the prayer or whatever else like that. It would be really fascinating to go back and talk to the legislators in 85, 95, 2000, 2016 and figure out why in the hell this was so important. But the language in there is pretty bizarre. But I guess it's that, and this one up here, if they're trying to treat their cancer or their condition by spiritual means or prayer alone, within the tenets of a quote well-recognized church, then that can't be exploitation alone. So I don't know if it's a not well-recognized church, maybe that could be exploitation. But that's just one of the crazy little quirks that's within there in statute. The bottom line, and I hope I've accomplished that in this fun section here, is understanding what exploitation is. And frankly, encouraging people, including lawyers, to understand it more. I had a meeting yesterday with a bunch of lawyers. These were primarily family law people, and they explained to me, we could see this being used a lot in family law cases, and yeah, they see a lot of that because they see people spiraling. Sometimes the reason why they're in divorce is someone spiraling, drug, alcohol abuse, whatever else, and this is absolutely a tool that loved ones, friends, family members can deploy to provide assistance and relief to someone that is suffering. So this has been a long one. I hope it's been an informational one for people. This is a broad topic that we're going to be finding out a whole lot about in the years and months to come. If you're interested in this, you got questions or comments, please drop a link in here, ask questions. I'll try and respond to you and provide that information. Thank you.